Mishcon Academy digital sessions.
Welcome to the latest Mishcon Academy digital session. We're absolutely delighted today to be joined by Laura Chandler, corporate partner at Mishcons, and Ben Woolgar, leading barrister at Brick Court Chambers. And today's topic of discussion is breach of warranty claims and also misrepresentation, because the two often go hand in hand. An observation we have had since COVID started is we're already seeing quite a few breach of warranty claims, breach of indemnity claims sort of trickling through. But since COVID really kicked off and has sunk in and Brexit is approaching, we're seeing more inquiries about breach of warranty claims, either kind of sellers who bought a company and now they've had it and had a chance to really look into it. There are issues arising, but also clients who have received a notification of a breach of warranty. So we expect this trend to carry on, there to be more cases like this. And we thought it's a good opportunity to go back to basics on breach of warranty, but from a corporate lawyer's perspective. So Laura, you spend a lot of time negotiating things for buyers and for sellers and making sure those breach of warranties are either as wide as possible or as tight as possible. And I think we'll start off by finding out from you actually precisely what are they, why are they important, and how do you negotiate them?
So I suppose starting from the very beginning, what is a warranty? So a warranty is a statement of fact. So you might have a warranty that the company, the target company, is not involved in any litigation or any disputes. Should it turn out that that statement is not true, the buyer would then look to bring a warranty claim for breach of that warranty, i.e. there is some dispute or there is some litigation that they weren't made aware of, and therefore they will need to show that they've suffered loss and they will bring a warranty claim accordingly. From a seller perspective, it's about telling them everything, and from a buyer perspective, it's about finding out as much as you possibly can. And if things don't make sense, go back and ask, or your lawyers will go back and ask. Before you actually sign on the dotted line, you should be finding out as much as you possible about the company. And the warranties then back up that due diligence process. So they're not a substitute for. You shouldn't be saying, it's fine, I'm not really going to look under the bonnet of this because I've got 25 pages of warranties being given by sellers, because you can quite quickly come unstuck if, for example, the seller has no substance. They've taken all of the cash out that you've given them for this purchase, and you're chasing either an empty shell or you're chasing individuals that have sort of siphoned off their money and put it somewhere that you can't reach. And so much better that you know exactly what you're buying from the outset, and that you're not then trying to chase to try and recover some of the money that you've paid across.
Is it sufficient for a seller to say, look, there are these 5 documents dotted around the data room, and actually if you look at them all in context in the right order, the buyer would have been able to work that out? I mean, Ben, from your perspective, would that be a good defence?
It would really be a sensible strategy. It would depend on the particular construction of the warranties, but normally in share sale agreements, it's important to remember that the data room, the contents of the data room don't modify the express warranty. So if you have said, for instance, you've got a no litigation type warranty in your share sale agreement, and buried in the data room, actually there is a claim form from somebody that shows that there was this one piece of litigation, that won't be a defence, because it's a promise that a particular state of affairs is true, actually notwithstanding what is true in the underlying facts.
And just following up on that, Annabelle, one of the things that as a corporate lawyer we spend quality time arguing over with the share purchase agreement is, what is the definition of disclosed? So the seller gives warranties, and then sitting alongside that warranty is something called a disclosure letter. And in that disclosure letter, you give specific facts. So for example, on that piece of on the litigation warranty that I flagged, if there's a piece of litigation, as Ben says, shoving a document in a data room that sometimes can run to thousands of documents, shoving a document in there that's a piece of litigation, it isn't really going to do it. Much better to say in the disclosure letter, there is this piece of litigation, please look at document 7.2.13 in the data room, and that will provide further details on it.
What about the claims notification clause? Because I've seen a variety of different ones over the years, and obviously the key thing for any claimant is that you need to stick to that as close as possible. But from a negotiating non-contentious perspective,
so often the claims notification piece will sit hand in hand with the limitations of liability for the seller. So you will look at, or if you're acting for the seller, you will look at limiting the period in which a claim can be brought to a certain period. So let's say for general warranties, typically you might see it being between 12 months and 3 years. For tax warranties, somewhere between 4 and 7 years. And within that schedule also you have the mechanism that says how you have to go about notifying the other side of a claim. So again, from the buyer's perspective, you would say, well, if I become aware of a claim, providing I tell you about it before the claim period's up, that's fine. From the seller's perspective, they will say, no, you need to, as soon as you've become aware of this, you need to tell us about it. And if you don't then actually issue proceedings within 6 months, 9 months, whatever it might be, then that's dead, that drops dead.
There's a long line of cases getting knocked out because they haven't followed the notification provisions of the SPA. So I think you're absolutely right. When we're drafting notification letters, that's something we have absolutely in the forefront of our minds. And Ben, from a sort of case law perspective, where do you see sort of developing trends on that?
I think one of probably the biggest trend in this area concerns what needs to go into a notification letter to constitute a proper notification. It's quite rare to have a dispute about whether or not a notification was made in time, but what you often do get an argument about is that the notification clause will contain some particular criteria for what the notification has to contain. It often says something like, in reasonable detail and indicating the likely level of damages claimed or words to that effect. But the courts have generally been quite lenient with what actually needs to go into a notification letter. They've normally taken a fairly generous approach. And the reason for that is that they say the whole purpose of these clauses is not necessarily to activate the dispute at this stage, but simply to tell the sellers how much they need to make provision for in their accounts, how much cash they need to set aside for these breach of warranty clauses.
And Laura, what's in your experience, is the common provision, do people treat it by way of escrow monies, or what are the kind of trends in terms of SPA and how you deal with breach of warranty claims? Do people use escrow accounts?
They do, but not generally for warranty claims. So if there is an issue, so let's say we've agreed a 10 million purchase, and actually doing our diligence, we find there's a £500,000 hole, then it might well be that actually before you even sign on the line, buyer and seller have another discussion, and buyer says that 10 million now looks like 9.5 and this is why, and seller says call it 9.6, and you've got a deal, and you sort of do a horse trade before you actually sign on the line, and that's done. If there's potentially a piece of litigation lurking in the background, what you will likely do at that stage is say, I'm going to ask for a specific indemnity in relation to that potentially known liability. And that's when you will start to talk about escrows, because it's something that could very well materialize. So it's a known piece. And so you might say, look, we've gone away and had a look at this, and we think potentially this litigation could be to the tune of £250,000. Therefore, we're going to hold back £250,000 of the purchase price, and we're going to put it in escrow. And as and when that piece of litigation is decided either way, the money is there. We've not got to go chasing the seller through wherever it is to get the money back. In terms of warranties, of course, if through the disclosure process the seller has made you known of an issue with the warranties, and you've decided not to push for an indemnity, then your claim is not going to be forthcoming for a breach of warranty claim, because in essence they've disclosed against it and you've not got it. So this is why with warranties, it's the position sort of last resort almost. You've gone through diligence, you've gone through disclosure, you've worked out whether there's anything that needs to be locked off the purchase price, strike one. You've worked out if there's any specific indemnities that you need, potentially backed by an escrow, strike two. The warranties are there for anything that's not cropped up through that whole process. And therefore it would be unusual to say, just in case there's something else, I'm going to put something in an escrow. And so you are, to the extent you've got a warranty claim, largely chasing the seller who's obviously, taken the money that you've paid across as a purchaser, and hoping that that money is still around, and that you can still claim it.
I think that brings us on to remedies. Do you want to talk us through the remedies for breach of warranty cases?
You calculate damages for a breach of warranty claim in a share sale or asset sale agreement on the basis of the difference between what you actually paid for the business and what the business was worth in truth. The reason that that is important is that sometimes you have a case where somebody has warranted profits of £30 million a year, and the true level of profits are £20 million a year, and the buyer gets hold of the business and they say, oh great, there's a gap of £10 million, I must be entitled to that whole difference. But it's not that simple, because the way you calculate damages is on the basis of the value of the business. So instead, what you'll normally end up doing is getting forensic accountants crawling all over the business and trying to work out what the basis of the valuation at acquisition was and what the right basis to value it on is now. Often there'll be questions about whether or not the right basis is a net asset valuation basis or a discounted cash flow basis, etc.
This brings me on to claims for misrepresentation, which sort of correlates really with the increasing number of breach of warranty claims we're seeing, the increasing number of inquiries about misrepresentation in particular. I wondered if you would just briefly talk us through the different types of misrep and the test and the remedy for each one.
There are three different types of misrepresentation at the most basic level, and they are innocent, negligent, and fraudulent. So we define misrepresentation cases essentially by the level of culpability of the person who made the representation. And that's important because there are then different requirements for showing loss and what remedies are available for each type. In an innocent misrepresentation case, the most simple case, a vendor has made a certain representation about the state of their business. And actually that wasn't true, but either they couldn't have known that at all, or they couldn't have known it with reasonable diligence. The second category is negligent misrepresentation. And this is where you said the thing and you didn't know that it was false when you made the representation, but you essentially could have known if you'd exercised reasonable diligence to find out. The paradigm case that you really see in a commercial context, and by far the most common and interesting misrepresentation claims in commercial settings, are fraudulent misrepresentation cases. So very briefly, I'm just going to run through the elements of a fraudulent misrepresentation using a very simple example from a share sale context. So you need essentially 5.5 things to prove fraudulent misrepresentation. First, you need a representation. So to take a very simple example, the seller needs to have said, my business had profits of £1 million last year. And you will then get into arguments often about whether or not the particular words that somebody said did actually constitute a representation of a particular fact. Second, the representation needs to be false. The business, let's say, only had profits of £500,000 last year. Third, the seller needs to have intended that the purchaser should rely on that representation. So sometimes you get the case where the transaction was cooked up in the wine bar and the very brash businessman said, oh mate, I've got this great new product line and it's making me £4 million a year, and everybody was a few drinks deep. And in fact, nobody really ever intended that that sort of statement would have legal consequences. Now that said, in a fraud case, intention to rely is presumed, because if you knew what you were saying was untrue, court unsurprisingly takes a fairly generous approach. Fourth, you need the person making the representation to have been fraudulent. That means they knew the representation was false, or they were reckless as to its truth, i.e. they didn't care. So the person making the claim that their business had £1 million of profits last year might just never have looked at the management accounts for that business. They didn't know what they were saying was false, in the sense that it wasn't present to their mind that they were telling a lie, but that is still fraud for the purposes of a deceit claim. Fifth, the purchaser has to have relied on the representation. Essentially, you have to ask yourself the question, what would I have done if I had been told the truth? Now, this is a surprisingly fertile ground for arguments in commercial cases. You frankly often get situations where the reason the person was buying the company was simply nothing to do with the representation that was being made, even though the representation was a flagrant lie. So those are the 5 full requirements. The reason I said that there's a half requirement is that there are essentially 2 remedies in a fraudulent misrepresentation case. Either you can rescind the transaction, and that means the whole contract is unwound, you give back the shares and you are repaid the money that you paid to acquire the business, or, and often rescission in these cases has become impossible because the business has already changed, you sue for damages. And if you're in the suing for damages territory, then you also need to prove that you've suffered loss as a result of the deceit. But that's not a full requirement, because sometimes you're simply saying, well, had I known of this fraud, I would never have done this deal. That's why I want to be able to rescind, even though I haven't actually lost any money by acquiring these shares.
I think it's worth pointing out that this jurisdiction does differ from others in that we can't professionally plead fraud unless there's a proper basis for doing so. But in terms of evidencing reliance and evidence of inducement and all those kind of things, that is where it does become quite complex, and you're very heavily reliant on disclosure and what comes up and how people documented their negotiations.
Absolutely. And I think reliance often is a very unusual stage of litigation to get to for business people, because they perfectly reasonably say, well, I was lied to. I was lied to about this business that I was buying. And ultimately, it is a subjective question of what was actually in the decision maker's mind at the time they made the decision. And that can feel very unusual to find themselves giving evidence about that. And sometimes you are purely reliant on your client's oral evidence. But what you really want and what you need to collate is all of the evidence of your decision-making processes. So what did you say to the board? What was in the board paper when you explained the rationale for the transaction? What were your accountants and your consultants saying in their reports about the business when you were reaching that decision? What projections were they making, and what projections were you looking at about cash flow or net assets and so on?
How long are you talking about for, say, a kind of fairly straightforward acquisition? How long would you spend negotiating the breach of the warranty and indemnity sections?
These things can be done fairly quickly if you've got sophisticated buyer seller and the commercial terms are agreed and there isn't a lot of work to do on disclosure and diligence. Equally, if you've got a very complicated company or you're going through bid processes or there are other things going on, it can also, it can take quite a while. I mean, one thing that's interesting now that we're seeing more and more is the use of warranty indemnity insurance. It used to be much more used for property SPV deals where you have a corporate that just holds the property, and less so for trading. But actually we're finding more and more now, because there are many more providers of the insurance, that the prices are coming down. It doesn't mean that you don't do the disclosure process. It doesn't mean that you don't do the diligence process. The insurers want to see that all of that has been done as diligently as it would have been done if you were going to have to put your hand in your pocket had there been a claim. But actually it's just, for an amount of money, it means that the sellers can go to wherever it is they're going off to, if that was their plan, knowing that, save in the event of fraud or willful concealment, that actually they are home and hosed should there be a claim, that actually it's a claim that they would need to be, that the buyer would need to be making against the insurance policy, not against the sellers themselves.
Ben, I think one last thing while we just have a few minutes left is the recent Marex decision, because obviously that changes the landscape a bit, and I wondered if you wanted to say a few words on that.
Marex is a decision about what is called in company law the reflective loss principle. Basically, in very simple terms, what this is is that where you are a shareholder in a company and a wrong has been done to the company, and your only loss is a fall in the value of your shareholding in the company, you personally do not have a claim. The claim belongs to the company. And this comes up a lot, both in the deceit context, where, for instance, you often have problems with empty shell companies at some point in the chain, and what somebody really wants to do is recover their personal losses. It also often comes up in the asset stripping context, where somebody has basically stripped the assets out of the entity that otherwise would have been on the hook. And Marex is a particularly interesting but also egregious example of that, because what happened in Marex was that there was a contractual claim brought by Marex against a company. It was a BVI company. The parties received draft judgment on that claim from the court, and normally when you get judgment from the court, you actually receive it in draft 3 or 4 days beforehand for the lawyers to suggest corrections and to deal with kind of consequential matters and so on. And Mr. Sevilleja, who was the defendant in Marex, was also the sole shareholder of the company. And what he did was simply transfer every penny out of the company's bank account into his personal bank account upon the receipt of draft judgment, so that the contractual claim for about £7 or £8 million succeeded, but there was no way of recovering on it. Unsurprisingly, the Supreme Court took a dim view of this conduct and was not enthusiastic about the idea of letting him get away with that behaviour. But his defence was, you, the creditor, Marex, don't have a claim against me personally, because what I did was wrongfully take money out of the company, and that is a claim that belongs to the company. What the Supreme Court said is, no, the reflective loss principle only applies in a narrow set of cases to do with shareholders of the company. It doesn't prevent recovery in conspiracy, for instance, on behalf of an individual, where they're only a creditor and not a shareholder. So how is that relevant here? Well, suppose you've bought a company from another company, and that company now has no assets. And in the course of the negotiations, various representations were made to you and they turned out to be false. You can now undoubtedly sue the individuals for asset stripping, thereby causing you not to recover on your breach of warranty or deceit claim in a way that was previously unclear.
I think that is all we've got time for today. But from Laura and from me and from Mishcon Academy, huge thank you to Ben Wilgar of Brick Court for joining us today. Thank you very, very much.
Thanks so much, guys.
The Mishcon Academy Digital Sessions. To access advice for businesses that is regularly updated, please visit mishcon.com.